Cronquist. I am Haley Cronquist. I'm the policy attorney at the Long-Term Care Community Coalition, and we are going to get started. Let's see if I can move my slide. Okay, so a little bit about us at LTCCC. We are a nonprofit, nonpartisan organization entirely dedicated to improving care and quality of life for the elderly and adult disabled in long-term care facilities. We are focused on policy research and analysis, systems advocacy, and public education. And we are also the home to two local ombudsman programs in the Hudson Valley here in New York. Please visit our website, nursingHome411.org, for all types of materials and resources so you can use for your advocacy purposes. So today's webinar, we have a really wonderful speaker today, Tanya Kessler. So as many of you may already know, nursing home discharges are a huge problem across the country. And our presenter today, Tanya Kessler, recently wrote a paper on the extent to which residents in New York are too often discharged with little to no assistance and too often to inappropriate settings. And so her paper and as well as today's webinar are titled Involuntary Nursing Home Discharges, a Fast Track from Nursing Homes to Homeless Shelters. A little bit about Tanya. Tanya is a senior staff attorney at Mobilization for Justice here in New York, where she represents residents of adult care facilities and nursing homes in matters related to civil rights, healthcare, housing, and benefits. She was also previously staff attorney on the Three Quarter House project at Mobilization for Justice, where she focused on housing rights of people living in illegal boarding houses. And so before I hand it off to Tanya, I just want to remind people to please put your questions in the Q&A at the bottom of your Zoom screen, and we will do our best to address those questions at the end of the program. So I'm going to hand it off to you, Tanya. I'm going to switch our slides here. And you should be all set.
Great. Thank you so much, Haley. And thank you to the Long-Term Care Community Coalition for inviting me to present today. So this presentation is basically an overview of a white paper that Mobilization for Justice published this spring called Involuntary Nursing Home Discharges, a Fast Track from Nursing Homes to Homeless Shelters. Next slide, please. And just to give some background, Mobilization for Justice is a legal services organization based in New York City. We've been around since the 60s. We were formerly known as MFY Legal Services. And I work on our Disability and Aging Rights Project, where we provide legal assistance to nursing home residents, as well as residents of adult care facilities and assisted living, and to individuals with disabilities who are trying to access paratransit services. We published this white paper after we saw numerous problems in the discharge, involuntary discharge process through our representation of nursing home residents. And so the information from the white paper comes from our own practice, as well as from a review of all of the published decisions from 2018 by the New York State Department of Health following hearings to appeal involuntary discharges. Unfortunately, we received the 2019 hearing decisions very late, over a year after our Freedom of Information Act request. And so we were not able to incorporate those into the paper, but we reviewed them and they're quite consistent with what we saw in 2018. So that's really where the information from this report comes. Next slide, please. So just to give you an overview of what we'll talk about today, I want to first begin by talking briefly about discharge planning and community integration, and then give some legal background around discharge planning and the involuntary discharge process, describe our findings, both substantive problems and procedural problems we encountered, and then finally our recommendations. I'm going to try to move through pretty quickly in order to give a chance for people to ask questions. Next slide, thank you. So to begin with grounding principles, our work is really grounded in the protection and advocacy for the rights of people with disabilities to autonomy, self-determination, and community integration. And I think it's important to recognize how terrifying it is for a nursing home resident who is facing an involuntary discharge. In some ways, it's akin to a tenant facing eviction with the same, a similar kind of prospect of dislocation, of losing the roof over your head, a very scary moment. And then you also have the fact that the nursing home resident has been probably receiving from the nursing home, not just shelter, but all of their meals, their medical care, their medication, assistance with personal care like showering and dressing. And so just how very scary it is to face that. And too often, nursing homes don't provide residents the opportunity to participate in the discharge planning process. So residents sort of receive a notice out of the blue, and that really is not in line with what the regulations require. And it's also a real violation of their autonomy and self-determination. And community integration is really a key principle in the disability justice movement. The Olmstead decision from the Supreme Court interpreted the Americans with Disabilities Act to require that services be provided to people with disabilities in the most integrated setting possible. And what we see is very often discharge planning is not encompassing community integration principles, is not helping people to get back to the community. And the way it's done could very likely result in reinstitutionalization. But we'll talk more about that a little later. Next slide, please. So to begin with the overview of laws and regulations, the Nursing Home Reform Act of 1987 really centered person-centered care and made it paramount. And it's defined as to focus on the resident as the locus of control and support, and so to support the resident in making their own choices and having control over their daily lives. So all of the care provided by a nursing home is meant to be person-centered. Next slide, please. That includes discharge planning. Discharge planning is part of comprehensive care planning, and the facility is required to involve the resident and resident representative in the development of the discharge plan and inform them of the final plan. The discharge plan must address the resident's goals of care and treatment preferences. And I just want to note here that the citations I've included are to the federal regulations, since I know that folks from different states are attending this workshop. But the white paper also has citations to the New York State regulations. And so if you're from New York State and want to see the local sources of regulations, you can find it in the white paper. And I'll also note there's a lot more detail in the white paper. So please download it if you're interested in more information. Next slide, please. Part of discharge planning is preparation. And the federal regulations require that a facility provide and document that they've provided sufficient orientation and preparation to residents to ensure safe and orderly discharge from the facility. And the orientation must be provided in a form and manner that the resident can understand. So this could take many different forms. It could be, for example, I've had several residents who were preparing for discharge who had not had the opportunity to self-administer insulin in some years in the time they've been living in a nursing home. If they're preparing for discharge to a setting that's not going to be providing that service, it's really important that they have training and practice self-administering insulin in order for it to be a safe and orderly discharge. That's just one example. Next slide, please. More good language on the focus of discharge planning. There three things that discharge planning should be focusing on: the residents' discharge goals, the preparation of residents to be active partners and effectively transition them to post-discharge care, and the reduction of factors leading to preventable readmissions. And I think this last point is really important to the shelter discharges that we see so frequently in New York State, and particularly in New York City. When people are going to an environment that has little to no services, coming from an environment that's providing a lot of services, the chance that somebody could wind up really declining, having a lot of medical problems, winding up hospitalized and back in a nursing home is high, and that is a preventable readmission. Next slide, please. So to talk more generally about comprehensive assessment and care planning obligations, those are supposed to begin at the inception of the nursing home stay. And one of the main tools for that is the minimum data set, also known as the MDS assessment, which is a pretty lengthy form with a lot of questions to be filled out. It should be done at least quarterly. And there's a section Q, that is specifically designed to give residents a direct voice in expressing preference, and the facility a means to assist residents in locating and transitioning to the most integrated setting. And so section Q is asking residents whether they want to return to the community. And this assessment should be done on a quarterly basis. So there should be plenty of opportunities for residents to voice that preference. And the nursing home then should be making a referral to a local contact agency to assist them in accessing community housing. Next slide, please. As I just explained, the nursing home is obligated to help residents access the services to obtain community-based housing and services. Next slide, please. Another important avenue for some residents to access community-based services is the pre-admission screening resident review, or PASR review. And those are assessments that are required for residents who have known or suspected mental health disabilities or developmental disabilities. And the purpose is to ensure that they are not unnecessarily institutionalized. Prior to admission, at least annually, and then upon a significant change in condition, the PASR review is supposed to be conducted. And if appropriate, the resident should be helped to access community-based housing and services. Next slide, please. So shifting from care planning obligations, if a nursing home determines that it wants to discharge or transfer a resident, there are limited bases on which they can do so. If the resident is viewed as a troublemaker, is making too many complaints about the quality of care, or has behavioral issues that the nursing home feels they can't manage, those are not allowable bases for discharge or transfer. There's only 6 bases that that would be upheld if the resident appealed the discharge. The first one is that the discharge is necessary for the resident's welfare and the resident's needs cannot be met in the facility. And I'm just going to use the term discharge instead of discharge or transfer throughout this presentation. The second is that the resident's health has improved sufficiently so that they no longer need the services provided by the facility. The third is that the safety of individuals in the facility is endangered due to the clinical or behavioral status of the resident. The fourth is that the health of individuals in the facility would otherwise be endangered. Next slide, please. The fifth is that there's been a failure to pay after reasonable and appropriate notice. And the sixth is that the facility ceases to operate. And I'll just note that there are some additional components to several of these, including failure to pay if there are charges that are in dispute, if there's a pending appeal of Medicaid, for example, then there's not a basis for failure to pay. So there are some additional details to know, but this is sort of a broad overview of on what basis a nursing home could properly discharge a resident. Next slide, please. So residents are entitled to a notice prior to being transferred, discharged. And the general rule is that that should be a 30-day notice, but there are quite a few exceptions. So if the safety or health of others in the facility would be endangered, that's an exception. If the resident's health has improved sufficiently to allow for a more immediate discharge or transfer, if it's due to the resident's urgent medical needs, or if the resident has not resided in the facility for 30 days, say they've only been there for 2 weeks. It should be noted that notice is still required even if an exception applies. It just doesn't have to be 30-day notice. The facility must still give notice as soon as practicable. That's not defined in the regulations, but it should not be the day of the discharge. Next slide, please. So there are a number of requirements of the notice. First, it must be provided to the resident and their representative in a language and manner they understand. So, for example, residents who have limited English proficiency should be receiving the notice in a language that they understand. A resident with visual impairments should be receiving the notice in a format that they understand. Next slide, please. Then there are a bunch of components that are required to be included in the notice, including the reasons for the discharge, the effective date of the discharge, the location to which the resident is being discharged, the regulations that support the discharge, the right to appeal and how to file an appeal, contact information for the long-term care ombudsman program, and for residents with developmental or mental health disabilities, contact information for the state's designated protection and advocacy program. Next slide, please. The resident has the right to appeal the decision to discharge within 60 days of receiving the notice. If the appeal is filed before the discharge is effectively stayed until a hearing is held, an appeal decision is issued. An exception is if the facility alleges endangerment to the resident or others in the facility. And if that's the case, the facility must document the danger that failure to transfer or discharge would pose. Next slide, please. The nursing home is required to have various types of documentation. So in the nursing home record, the nursing home must document the basis for the discharge, not just in the notice, in their record. And the resident's doctor must complete the documentation if the basis is that the resident's health is improved or that their needs cannot be met at the facility. If the basis is the danger to the safety or health of individuals in the facility, a doctor must complete the documentation, but it doesn't have to be the treating doctor. So it's really important if you are advocating for yourself or a loved one or are serving as an advocate for someone to take a close look at the basis for the discharge, because who must document that basis could depend on what that basis is, and that could be a reason to challenge the discharge and at least get another notice issued or buy some time at the very least. Next slide, thanks. The appeal hearing. So in the hearing, the nursing home bears the burden of proving that the discharge is necessary and the discharge is appropriate. So essentially, number one means the nursing home has to show that they do indeed have the basis they claim they have. And number two is they have to show that they have a safe and appropriate discharge plan. Residents have a right to represent themselves, be represented by counsel, or they could have a relative, a friend, or other spokesman be with them in the hearing. They also have a right to records. They must have the opportunity to examine the nursing home file and any documents the nursing home will use at a reasonable time before the date of the hearing. And that's usually very helpful to understand exactly what the nursing home is alleging. Next slide. The conduct of the hearing. The resident may bring witnesses, may question or refute testimony, including by cross-examination. In New York State, judges have the power to obtain medical assessments and psychosocials and issue subpoenas. And if an administrative law judge determines that an impartial medical assessment is necessary, it must be obtained at the expense of the state Medicaid agency. This is really an unenforced regulation in our experience. I'll talk a little more about that later. The decisions on appeals are issued in writing and inform the parties of the process to appeal the decision. But the discharge generally is not going to be stayed pending an appeal after a hearing, unless a court issues some kind of stay. Other rules to consider: in New York State, there's a manual for administrative law judges that applies to all fair hearings and includes instruction to judges on how to assist pro se litigants, people who do not have legal counsel. There are also state regulations regarding shelter admissions. And in New York City, the Department of Homeless Services has an extensive policy on shelter admissions with rules and eligibility requirements and documentation that must be submitted in advance. So it's important to take a close look at that policy if the resident who's facing discharge is to a shelter in New York City. There are also federal rules on publications of decisions requiring that involuntary discharge decisions must be made available to the public. Unfortunately, in New York State, they are not at this point. Next slide, please. So now I want to talk about our findings in this report. First and foremost, we found numerous failures of discharge planning by nursing homes that sort of as a matter of course, nursing homes were failing to conduct discharge planning as part of the comprehensive person-centered care planning. Three of the most common problems in discharge planning were a failure to obtain needed benefits, services, and housing, a failure to comply with shelter referral requirements when seeking to discharge someone to a shelter, and a failure to ensure that residents move to the least restrictive setting appropriate to their needs. Next slide, please. So to give some context for the discharge planning failures, we find that the New York State Department of Health is failing to enforce discharge planning standards. We rarely see any citations to nursing homes in their inspection reports for failures to comply with discharge planning requirements, even where we've seen decisions where there's some recidivist nursing homes that are repeatedly doing things like refusing to take people back from the hospital without giving them a notice and without working on any kind of appropriate discharge plan. And discharge planning failures are a long-standing problem, not just in New York. The Health and Human Services Office of the Inspector General issued a report on this back in 2013 and has announced that they have a forthcoming report that's expected to be published next year. So it's a long-standing problem and one that needs to be addressed right away. Next slide, please. So on the failure to apply for or obtain needed services prior to discharge, I just wanted to give some specific examples. The first two examples come from the 2018 hearing decisions. One example was a nursing home trying to discharge a resident to her home. She had suffered numerous falls and the facility did not ascertain whether home care was available for her or what devices were needed to maintain her safely at home. This came out in the hearing and was noted by the judge. They were simply seeking to send her home without ensuring that she had those safety features in place. Another was a nursing home proposing to discharge a resident who uses a wheelchair to an assisted living facility that does not accept residents who use wheelchairs. That is in itself a violation of the law, but it, raises the question, where in fact would that resident end up going if the proposed discharge location is not accepting the resident? That's not a proper discharge plan. And then an example from one of our clients, our client was discharged to an apartment through a waiver program, a Medicaid waiver program, which was great news for her. But unfortunately, when she went home, she didn't have the durable medical equipment she needed. She didn't have sufficient prescriptions. She didn't have home care services in place. And even the referral to a primary care physician was to a provider who did not accept her insurance. So she had no planning on the part of the nursing home. Next slide, please. Another issue is the failure to comply with shelter referral requirements. And as I mentioned, the New York City shelter system has specific referral requirements, which are intended to ensure that people coming into shelter can get the services that they need in shelter. So there are certain exclusionary criteria because the shelter maintains, there are certain kinds of services that cannot be practically provided in homeless shelters. And there are procedures to request reasonable accommodations in advance. Yet, New York City nursing homes routinely discharge to shelters, even when residents have service needs that the shelters cannot meet. And we see them sending applications to shelters that are incomplete, that are with wrong information, that claim that people can take care of certain self-care needs on their own that they can't, and without requesting reasonable accommodations. And we see that administrative law judges uphold decisions to discharge to homeless shelters, even when there's no evidence that any attempt was made by the nursing home to find a more appropriate setting. Next slide, please. So to give a little more background about sort of the extent of the shelter discharge problem in New York City, in 2018, almost 3,000 nursing home residents were discharged to homeless shelters, according to the best information we have from the City Department of Homeless Services. Yet when we review the 2018 hearing decisions, only 31 of those decisions involve a proposed discharge to a shelter. So the vast majority of residents facing discharges to shelter are never even getting to have a hearing. And we're going to talk about some of the procedural problems that, that make it so that residents sometimes don't even have the opportunity to file that appeal. When there was a hearing for a proposed shelter discharge, the nursing home prevailed in 81% of those cases. So nursing home residents have a very steep hill to climb to challenge their discharge to a homeless shelter. It's become an accepted practice for nursing homes to discharge residents to homeless shelters. Next slide, please. Then another of the major issues, failure to seek the least restrictive setting. So we see that frequently nursing homes are failing to use the PASSER process to enable residents with mental health or developmental disabilities to access community housing. Our clients sometimes haven't even had a PASSER assessment. Failure to refer to or follow up on referrals to local agencies for housings through waiver programs. So that's the MDS section Q. A lot of times that's just checked off. No, the resident isn't interested in community housing, though our clients will tell us, I've been saying I wanna find an apartment in the community since I moved in. So it seems that there's not sort of a genuine inquiry happening around that. And then we've had clients who are in the process of obtaining community housing who were being discharged to homeless shelters, and their housing applications were put in jeopardy because that housing was only available, the waiver program was only available to individuals living in nursing homes. So by placing the person in a homeless shelter, that would be actually cutting off their opportunity to obtain that safe and appropriate housing. Next slide, please. Then another issue we see is a misunderstanding of eligibility for nursing home care. Nursing homes frequently argue in discharge hearings that discharge is appropriate because the resident no longer needs skilled services. But in New York State, all nursing home beds are dual certified, both for skilled services and for long-term services. Nursing homes cannot discharge residents on the basis that they no longer need skilled services if they do still need custodial services. Next slide, please. So there's a helpful CMF infograph, custodial care versus skilled services. It sort of describes the differences between these types of care. And I think there's a link to it in the chat. But it just is a simple chart that shows the types of services like wound care, rehabilitation, that are skilled care, and custodial care, which tends to be assistance with activities of daily living, like showering, bathing, toileting, which are critical services for many residents. Next slide, please. So the discharge appeal decisions misapply the standard for discharge, and judges are adopting this reasoning around skilled services, even though all facilities in New York State provide both skilled services and custodial care. We see, these are quotes from the decisions. Resident has reached maximum rehabilitation potential. That may be true. And if it is true, the question is, do they still need custodial services? Because if so, they're eligible for nursing home care. Appellant no longer needs skilled care in a nursing home. The third one is interesting. If the appellant is well enough to live in an apartment in the community, the appellant does not need to be in a nursing home. Well, that's not quite true, because there are a number of services that are available both in the community and in a nursing home. There may be an Olmstead question there. Is the resident interested in living in a more integrated setting, and have they been afforded that opportunity? But that's an entirely different question from, does the nursing home have a basis to discharge the resident? And if they still need services from the nursing home, then that's not a basis for involuntary discharge. Next slide, please. So now I want to shift from the substantive issues to procedural problems in the discharge process. Certainly, we see numerous instances where notices are not being served as required. In addition, notices must be furnished to the long-term care ombudsman program, but we hear from the local program in New York City that they're often sent late and sometimes not sent at all. I'll note that the long-term care ombudsman program is severely underfunded, and so their capacity to follow up with residents for whom they receive notices is limited. A few years ago, there was a requirement added that the program be provided with the notices, which is a good thing, but it was not accompanied by an increase in funding. And just to give a sense of the scope of the problem in New York, in New York State, New York ranks 40th among 50 states for the number of full-time ombudsmen per long-term care bed. And in New York City, where the ratio recommended for long-term care ombudsman is 1 for every 2,000 residents, in New York City, the ratio is 1 for every 8,650 residents. So access to advocacy services by residents is severely limited. Next slide, please. Some additional procedural problems are the effectiveness of the notice. The notices to discharge or transfer can be very difficult to understand. There's no standardized format. The basis is often a box that's checked. So there's a list of the 6 bases, and one of them is checked off, but no underlying facts are provided. So the resident has very little information about why the nursing home is seeking to discharge them. They're frequently only in English, even when the resident or their representative has limited English proficiency. Next slide, please. They're often small type, hard to read, particularly for aging folks in nursing homes. And they are seldom in an accessible format, even when the resident has a known visual impairment, for example. The confusing layout can make it very difficult to tell who to contact to request an appeal. Next slide, please. So here's an example of a confusing notice. This is, I just sort of cut and paste a piece of a notice from a former client. So the notice is required to have information on how to request an appeal. Now this lists 3 places to contact, but in fact, the only agency that can process a request for an appeal is the New York State Department of Health, the first agency listed. So if a resident tries to reach the DOH and can't get through, and then they might say, okay, well, maybe I'll try the next one and I can file an appeal with them. Well, they may be able to get assistance from the other organizations to file an appeal, but contacting them is not filing an appeal. And we've heard from the local long-term care ombudsman program that they've received appeal requests from residents who think they are filing an appeal. So this is just one example of a confusing layout that, that is unclear and can result in a resident not actually filing an appeal and thinking that they have. Next slide, please. So to talk a little more about the challenges filing an appeal. Even if the resident knows who to contact, it can be difficult to get that appeal filed. In New York State, appeal requests go to the nursing home complaint hotline. And generally there's sort of an intake person who will then refer you to the nursing home division. And what we hear from residents is they seldom reach a human being on the first try. So they may be leaving a message. And it can be really difficult for nursing home residents to get return calls. A lot of our clients don't have their own phones. A lot of times they're dealing with calling a nurse's station on a floor. And so once they've left that message, they don't really know what's happening and are unable to confirm that their appeal was received. Generally, the Department of Health will eventually send out a letter confirmation once the appeal request is received, but it's really challenging to get to that point. Next slide, please. I want to talk about legal representation in the discharge hearing process. Looking at the 2018 hearing decisions, nursing homes were twice as likely as residents to have legal counsel. Nursing homes had counsel in 19 cases, residents or their guardian had counsel in 7 cases. So the majority of cases, no one had counsel, but nursing homes also have a leg up because they're more likely to have been through the discharge hearing process before. So, and they have more savvy with regard to the regulation. So even without counsel, they're in a better position. But to show what a difference counsel can make, residents who had an attorney won their case every time in 2018. By comparison, overall, residents won their case 42% of the time. Next slide, please. So some of the challenges for residents who don't have legal representation are, to begin with, it's not easy to refute the nursing home's record and their staff testimony. They sort of begin with an appearance of expertise and professionalism. And so it can be really hard for a lay resident to show that, in fact, this assessment is not on target, that these documents do not reflect the reality of what's happening for that resident. It's difficult to obtain conflict-free medical records and assessments. So, the assessments that the nursing home is submitting in support of their decision were usually conducted by their staff or their contractors. And so there's already a self-interest in the performing of that assessment. And we're not seeing judges in New York State requesting conflict-free assessments or using the power to get Medicaid to pay for them. We're not seeing judges issue subpoenas. There have been instances where residents said, I'm close to getting another type of housing. And the judge said, well, you need to bring the evidence of that. It can be really hard for residents to get the documents they need. Judges aren't helping by issuing subpoenas either for witnesses or for documents. Next slide, please. Then the challenge with using the nursing home records are quite a few. One is that the records are often provided a day or so before the hearing, and sometimes the same day. They can be rife with medical terminology and difficult to use. I know I find myself Googling a lot of terms that I see in nursing home records, and they can be voluminous. So it can be very difficult to find the pertinent information unless the records are provided in a text searchable format and you have a computer accessible to you to actually do that text searching. That's a very rare circumstance for a nursing home resident. And then there's also the question of knowing what kinds of documents might help refute testimony. What kinds of documents even exist in the nursing home record? So for example, if the nursing home is saying, this resident doesn't need any help with showering or dressing, there are nursing home records that'll show exactly what assistance the resident has been receiving. And that might contradict what the nursing. So without knowledge of the intricacies of the regulation, such as the treating physician being required to document the reason for discharge if the person is assessed as no longer needing nursing home care, it's hard to advocate for oneself without having that knowledge. Please. Then there are challenges during the COVID-19 pandemic in particular. First, the moratoria on evictions that applied in a number of localities and states and on a federal level were not applied to involuntary discharge hearings. Those hearings went forward even during the pandemic. There was a real lack of access to nursing homes by advocates and family members, as probably everyone who's watching this presentation knows, and had an enormous effect on residents' lives in many, many ways, but including in the discharge hearing process. It meant that residents were not able to easily consult with advocates and family members about discharges and weren't able to have their advocates and family members present with them during the hearings. Most hearings in New York State take place in the nursing home. The judge comes to the nursing home and the resident is there. And if they have an advocate or friend or family member, they're there in the hearing as well. In New York, the hearings were conducted by video conference during the pandemic. So that meant it was just the resident alone in the room with the nursing home staff testifying against them, with no judge present to mediate and no advocates present either. A super intimidating experience for residents. And I can say that as an advocate, I found it challenging to even obtain the opportunity to talk with my client privately during the course of the hearing, as I would have easily if I was present with him. Facilities improperly tried to use the limited exceptions to transfer procedures that were made to enable COVID cohorting. So there were certain narrow exceptions to the usual procedures if nursing homes wanted to cohort separating COVID positive and COVID negative residents, but they really tried to take those exceptions and run with them. And discharges to homeless shelters and other unsafe settings continued during COVID. And there's a very good article from the New York Times from June of last year. There's a citation at the bottom of this slide that described some of these problems that continued to occur during COVID, and people were facing discharge to congregate settings right in the middle of the pandemic. Next slide, please. So we made a number of recommendations to address some of these substantive and procedural problems. The first is for nursing home residents to have a right to counsel in discharge hearings. In New York City, it is still in the implementation phase, but tenants now have a right to counsel in housing court. And we think that nursing home residents should similarly have a right to counsel because of the tremendous power imbalance and challenge they face in appealing discharge decisions. Number two, the existing regulation should be enforced. There's, some powerful language around the obligations of nursing homes to ensure that resident goals are part of discharge planning and that they're preventing readmission in discharge planning. That means getting the proper services in place. Those regulations must be enforced because nursing homes don't seem to fear any consequence by violating them. The existing regulations should be strengthened. In New York, for example, assisted living regulations require that facilities show that they made persistent efforts to find an appropriate alternative placement before terminating an admission agreement, and are pretty specific about what those persistent efforts should look like. The regulations are not so specific for nursing home residents. The notice to discharge should be standardized to ensure that it's readable for all residents. The process to request an appeal should be simplified. There should be a direct line, or the resident should be able to contact the adjudication bureau, which handles the hearings directly. Funding for the long-term care ombudsman program should be increased to enable residents to have much more access to advocacy services around discharge, comprehensive care planning, and so many other quality of care issues. And discharges to homeless shelters should be prohibited. Recently, the New York State Legislature passed a law that discourages discharges to homeless shelters, which was an important step. But in our view, they should not be permitted at all. Finally, administrative law judges need training on a number of topics from our review of the decisions that have been issued. Number one, they need better familiarity with federal and state requirements on comprehensive care planning, discharge planning, the PASSER process. They need to understand the difference between skilled services and custodial care, and in New York State, understand the dual certification system that exists. They should be familiar with the standards for admission to other settings like assisted living programs and shelters. They should be trained on how to seek independent assessments paid for by Medicaid, when to issue subpoenas, and on how Medicaid waiver programs and other programs work that are designed to assist nursing home residents transition to community settings. All of that is relevant to the decisions they render, and when nursing homes are making representations about the efforts they've made to place residents, it's important that the judges are informed about what the options are and what steps nursing homes are required to take to help residents access safe and appropriate housing. So that is all for my presentation today, and that leaves us with a little bit of time for questions.
Great, thank you, Tanya, so much. That was so informative and interesting, and also maddening. I know that your paper was focused on New York, and part of this presentation was as well. But I think it's important to recognize that it is a national problem. So before we move on to the Q&A, I'm going to switch my slides here if I can. I would just like to promote an event that we have coming up in September. It is our next webinar. It will be on Tuesday, September 21st at 1 p.m. Eastern. And our presenter for that webinar will be Dave Kingsley. He is a researcher specializing in healthcare policy and economics. And he will be discussing the hidden profits behind poor nursing home care. So that will be in September. You can register at the link on the slide there. And then I will also ask Eric to put that registration link in the chat. And you can also find all of our webinar information on our website at our webinars and events page at Nursing Home 411. And then also save the date. LTCCC is holding our annual event this year in person, which is very exciting. So it will be on November 9th from 6 to 8 p.m. at the New York City Bar. And we are really, really looking forward to that. So you can find more information on the link there. And then also we'll be promoting that event as time goes on. So really looking forward to that. So thank you again so much to everyone who joined us today. And thank you to Tanya for a really important presentation. And lastly, for any updates and invites for future programs, please visit us at www.nursinghome411.org/join. And for any ombudsmen who joined us today, there is a survey there for you to take. So you can go ahead and do that, and Eric will put that in the chat as well. Okay, I'm going to stop sharing now, and we will move on to the Q&A. I think we have a lot of great questions that came in. Okay, so the first one here is from Jack. So he says that nursing homes are now using guardianship proceedings to force a discharge. Could you discuss, please, can a nursing home or a hospital send, sorry, this one's a little bit confusing. I'm a little bit confused by this question, actually.
Yeah. We'll get to, let's start with the first one, because I know Jack had a few questions and we can kind of spread it out.
Okay.
So yeah, maybe we'll just start with the question about guardianship proceedings to force discharges. Yeah. Is that something you've heard?
I'm not sure that. I think what we've seen more of is where guardians are inappropriately keeping people in nursing homes. I'm not sure if we've seen nursing homes use guardianships to force people out. Certainly, they've used guardianships to obtain payment for services where a family or a resident isn't paying. But I'm not sure we've seen it used for the purposes of discharge.
Okay. The next question here is from Maxine. It says, how many residents are really well enough to take an appeal? Where do they get representation, and which attorneys will help them with limited resources?
Yeah, I mean, I think that it's really hard for even residents who are quite well to take an appeal, but for folks who are folks who are suffering from cognitive disabilities, mental health disabilities, or who are experiencing a lot of medical problems, it can be even more challenging. In terms of finding an attorney, that's a real problem. And that's why we think a right to counsel is necessary. I mean, I think that other advocates can also be very helpful, like from the ombudsman program, if that's available. But generally what we suggest is if somebody needs an attorney for low-income people, lawhelp.org is a good place to start. So I can tell you in New York City, we do represent residents in discharge hearings on a case-by-case basis, but in other areas of the country, Law Help covers lots of different areas. You can search by geographic area. That's not to promise that there are always legal services available, but that's a good place to find resources, and you can search by sort of the type of legal problem.
The next question here says, is it common or possible for nursing facilities to attempt to discharge an individual arguing that they cannot meet the needs or accommodate someone's disability?
Yeah, that's a good question. You know, those we don't get a whole lot of cases on that basis at MFJ. We've had it from time to time, but the decisions show that that's frequently what nursing homes are alleging when they improperly attempt to discharge residents to acute care hospitals. So there's a bunch of decisions from 2018, those decisions that we reviewed, where the resident was admitted to a hospital. Often in those cases, it was a psychiatric unit in a hospital. And then the nursing home said, we're not taking them back. And that is not a proper discharge plan. And they can't base whether they think they can serve the resident on how they were doing prior to the hospitalization. They have to reassess them once they've had treatment and have presumably stabilized. So that does come up, but there aren't a lot of settings that provide more services than a nursing home. And so I think that that's a, it's a rare instance where a nursing home would not be able to provide the services that a resident would need, where somebody would need more services than a nursing home could provide.
Our next question is from Sandy. It says, if the health of the resident has improved sufficiently and the facility needs the bed, but the resident refuses to cooperate regarding a discharge, what are the options for the nursing home? And in this particular instance, a physician has indicated that she is fully able to live on her own.
The option is to serve her with a discharge notice, and if she elects to appeal it, to argue the case in a hearing. I mean, that's the process. And so, the fact that a doctor said that was the case, that is required in order to commence that discharge. They have to document that a doctor said that they no longer needed the services of the nursing home. But that doesn't end the inquiry. It's up to a judge, and there could be other evidence that might indicate something different.
Okay. And actually, so speaking on judges, the next question is from Maxine again. It says, how do the ALJs justify their decisions to discharge when it's clearly inappropriate?
I have the same question. I think that sometimes they're crediting the nursing homes with they're crediting the nursing homes with, we're saying there's no other place, even if they haven't tried to find another place. And in a lot of instances, as I described, they're crediting sort of a faulty argument where they're accepting the premise that if you don't need skilled services, you don't need nursing home care. So I think that those are some of the issues that we see. In some instances, I think that nursing homes try to portray the resident as very uncooperative if they're not sort of accepting the first discharge plan that's proposed, and the judge might buy into that, though that's not really part of what they should be considering.
Okay, our last questions, we are at 2 p.m. now, so our last question is going to be from Tony Chicatel, our friend over at Canner in California. He says, I am shocked that New York policy endorses and the ALJs approve sending nursing home residents to homeless shelters. In his state, in California, discharge to a shelter is de facto inappropriate and will not be permitted if appealed. Do residents ever appeal the ALJ decision via writ of mandate or form of judicial review?
So residents can appeal the ALJ decision by filing a case in New York Supreme Court, which is the trial court in New York. I haven't seen any published decisions challenging a shelter place. And I think part of what's really difficult is that once a resident is in the shelter pursuing a legal case, and first of all, it's very hard to file that kind of case in court without counsel, but finding counsel and pursuing a legal case at that point becomes close to impossible because people are in survival mode and just trying to figure out how they're going to get the care they need, how they're going to find the food they need. I mean, shelters kick people out during the day, so they have to find out where they're going to be during the day. So it just becomes very difficult. We haven't had occasion to challenge one of those because they haven't really come to us soon enough after the fact. There's only 4 months to appeal that kind of decision, so it's a short window in New York State. So unfortunately, we see so few people facing shelter discharge, even challenging the decision in the first instance, such a tiny percentage. And then I think it's probably a very rare circumstance that somebody's able to pursue an appeal after the fact. I'm glad California has more protection.
Yes, yeah, that's really good to hear. It is really shocking to know that. So, we're going to end on that question. So, Tanya, thank you again so much. This was really, really informative, and I hope everyone found it as interesting as I did. So, thank you so much.
Thank you.
Yeah, thanks everyone for joining us today.